me, let me know. My name's Amanda Ashley. I'm one of the attorneys here in the Debt Recovery Department. And we're doing collection basics today. So on your screen, you should see the PowerPoint. It will take up the vast majority of the screen. There's also a small box on what should be your left-hand side. It's got a little question mark, and that will be the question and answers icon. So if you have any questions as we're going through, go ahead and type them there. And as soon as they pop up on this end, I will try to address them. You'll also see a video of someone talking. That's me, just in case this is your first time on a webinar. CMCA credits are automatically generated once the webinar is over and the host provides attendance confirmation. That'll be sent within 48 hours via email following the webinar, and the credits are non-transferable. If you have questions about the CMCA certificates, you will email education@altitude.law, or you can call Grace directly. Grace is the one who's putting all of this together and handles a lot of our certification and all of that. And her number is 303-991-2076. So that being said, one more item I suppose I should mention. We've been having some technical difficulties on this end. So if for some reason the system goes down or it appears that we're frozen, give us just a minute and we'll try to get back up and running. Hopefully we won't have any of that, but it was happening earlier this morning, so just a heads up. At any rate, we'll go ahead and get started. So what we do here is we get what are called turnovers from either your association or your management company. And pre-collection considerations are basically things we're going to look for prior to that turnover. And the biggest one is we're going to look to see if you've been following your collection policy and procedures and that you're in compliance with HB 1276. What that means is that's the House bill that was passed in Colorado in 2014 that kind of lists out the requirements in the statute that we have to follow and that the association has to follow in order to collect. Don't forget that the HOA, that's a business, and an association is a business, and it runs off of the assessments. They really are the lifeblood of the association. And so in order to continue that business, we have to collect the assessments if the owners aren't paying them voluntarily. So the board, which is, that's going to be, of course, your elected board, they have that fiduciary duty to collect assessments, either directly or through their management company. And we are going to look to make sure when we get a turnover that the collection policy, first of all, that you have one, but secondly, it's been followed as far as the amount of notices, the number of notices that have been sent out, whether or not they've been sent out according to the timeline set forth in the collection policy. And of course, we're going to make sure that that HB 1276 letter has been sent out, and that's that payment plan letter, which I'll get to in a minute. We also want to make sure that each owner in the association, each property owner, is being treated fairly. So we're going to look at things like whether or not you turned an owner over prior to sending out all the notices versus owners who regularly get the required notices. If for some reason we don't see those notices, or they have not been sent out, or they've been sent out incorrectly, we're going to bump that back to you. We're going to bump it back to you and say, hey, we have a problem. We need this sent out before we can go ahead and open the file and proceed. As far as the HB 1276 policy portion, the collection policy must absolutely have when the assessments are due and when they're considered delinquent, how much the late fees, interest, and return check fees are going to be. The return check fees cannot be over what the statutorily allowed amount is. And then the circumstances and terms of the payment plans. In other words, it says that the payment plan must be offered for a minimum of 6 months of payments, and that has to be offered to owners. It actually does not have to be offered to businesses. That's kind of a different animal, but certainly to property owners that are individuals. We will review the collection policy when it gets turned over. On the status report, you might see something that says we are reviewing the collection policy prior to turnover, or you might see a file that has been opened and says we're awaiting notices before we can proceed with the file. those are letting you know as the management company or the association that we are missing information that we need before we can proceed. The delinquency notice that's going to be sent out to the owners, especially the one that has to be compliant with that HB 1276, has to have the total due plus an accounting. It has to state whether the payment plan is allowed, and they have to be allowed in the beginning. Certainly if an owner is continually delinquent, there's some ins and outs to that. But in general, you want to make sure that that payment plan is set forth. The owner has 30 days to either cure the default or to contact the person, the contact information to set up a payment plan. And then it also has to set forth that legal remedies are available if not corrected. And legal remedies would include lawsuits, foreclosure, receiverships, so on and so forth. If we receive a file where a delinquency notice has not been sent to the owners on the property pursuant to the assessor's record, we won't be able to proceed with collection. We're not going to be able to send out a demand letter. So you'll see that on the status report reflection as well. It'll say we're holding the file for 30 days pending the forwarding of the HB 1276 letter to the correct owners. If the delinquency notice is sent to, let's say there's 2 owners on the account and it's only sent to 1 owner, we're going to come back to you and say, well, if you want to pursue all of the owners on the account, you have to send that HB 1276, the payment plan letter, the delinquency notice, to all of the owners. Otherwise, we can only proceed against the owner for whom you sent the notice. So be aware of that. We usually will, like I said, just bump it back and say, hey, can you send it to all the owners? Because we will have a better chance of collection against all owners than if we were proceeding only against the one. A few exceptions to that are if the assessor is still showing, we always pull the assessor report prior to proceeding. The assessor report is going to list who the owners were and when the property was sold to them. If for some reason the assessor's record has not been updated, but you are in possession of a recorded quitclaim deed showing who the property owners are, we can proceed that way. Those are kind of rare exceptions and we don't run across them. In fact, oftentimes when we get a quitclaim deed, it has not been recorded, in which case we have to go by who the assessor lists as the recorded owners. One of the things we're going to look at when we do get this file, sorry, I jumped ahead just a little bit there, is we are going to look at who we're collecting against. Boy, I'm having a heck of a problem here. Sorry about that. So we're going to look at who the debtor is, what asset information we may have at the beginning, and then the likelihood of recovery. So what I mean by who the debtor is, you're going to look to see if the property owner is an individual or a business. If they're a business, we're probably going to recommend foreclosure or receivership. We might be able to do a lawsuit, but that's a little more difficult with a business because we have to sue registered agents and notices and so on and so forth. We're going to look at asset information. When you first receive an email from our office stating that the turnover has been opened as a file, we're going to ask if you have any type of asset information. What we're looking for is banking information, for one. Do we have payments that the owner previously submitted to you that shows their financial institution, because we'll use that down the road once judgment is obtained. We'll also look at things like whether or not you know if the owner is employed. These are questions we're going to ask later as well, but we certainly ask them in the beginning, and that's part of what we're looking at when we get a file turned over. And then we're going to look at likelihood of recovery. For example, if we get a property turned over to us for collection of assessments and it turns out that the owner passed away 2 years ago, the likelihood that we're going to be able to recover from that owner individually is pretty slim. There might still be an estate open for probate. Oftentimes there isn't. There may not have even been one open. So we're going to look at things like that before we proceed, just because that way we'll kind of be in a position of knowing kind of a cost-benefit analysis. Is it going to be worth it for us to sue if the owner is deceased? Would it be better if it meets all of the requirements to foreclose to turn it over to our foreclosure department? So that's some of the things we're going to look at there. And if you'll notice, George has a little, the $100 bill has a little bit of a mask on it. I just thought that was funny. The other thing we're going to look at is whether the debtor is also an estate or a trust. So is the property name in the name of the Smith Trust? If so, that's going to give us some other hoops that we'll need to jump through. And then in-state or out-of-state. An out-of-state owner we can still sue, but we're going to have problems when we try to serve them with the lawsuit. If they're out of the country, we're certainly going to have issues trying to serve them or even contact them. And in light of today's COVID pandemic state, the other thing we're going to be looking at, and you'll see this on their status report, is whether we have to hold a file because we're unable to serve the person due to the restrictions that their state may have. For example, if we have an owner in California and we're trying to sue them from here in Colorado, well, California for quite some time had an absolute, basically a no contact order. They weren't allowing people, there was kind of a moratorium on debt collection. And so it made being able to serve the owners there impossible. So we had to place the file on hold until those restrictions were lifted in certain states so we could proceed with service when it comes to serving the lawsuit. Some of these states, like Massachusetts, actually had a bit of a moratorium on debt collection in general, which would have prohibited us from even sending a demand letter there. So in light of COVID, there's quite a few other considerations we have as well. As far as likelihood of recovery, when we get a file, I would encourage you to turn over the files pursuant to the collection policy, because generally the balance is going to be lower then, as opposed to waiting past when your turnover is specified in the policy, for two reasons. One, there is that lower balance, and two, we don't want to have to worry about whether or not we're treating one owner differently by turning them over later than we did another owner. But certainly a lower balance or a faster turnover, again in line with that collection policy, tends to allow us to recover more quickly because people can pay off lower balances. At least they can do. They tend to get on payment plans more often. They don't feel as overwhelmed. Certainly if we get an association that has turned over a file to us that's in the, let's say, $8,000 to $10,000 range, the likelihood that the owner is going to even feel like they're able to set up a payment plan or any option like that is pretty slim. So those are probably going to go to lawsuits, at which point then the attorney fees and costs increase. But certainly the lower balances, faster turnover, we're going to be able to recover a significant amount of those just because it's an easier burden for an owner to pay off. We're also looking, when it comes to likelihood of recovery, we're looking at public trustee foreclosures and bankruptcy. So if there is a pending trustee foreclosure, so a mortgage foreclosure, if you will, we don't have as long of a time to proceed before the foreclosure hits. That doesn't mean the association can't sue the person individually after that, but the association is losing a lot of its power because the owner no longer owns the property. So that background kind of looming the association could foreclose option no longer exists at that point. And then certainly bankruptcies, they just throw a wrench in everything, right? You have a bankruptcy, and we'll talk about them a little further, a little down the road, but bankruptcies are going to basically put a halt on everything. And that's called an automatic stay. And once the bankruptcy hits, it's going to severely limit what we can do and how quickly we can do it. There's some ins and outs to the bankruptcy. We can proceed in certain ways, but that puts a big halt on everything. So we look at that when we first open the file. You'll see that in the status report. It says that we will search public trustee to see if there's a foreclosure, and we're also searching to see if they're in bankruptcy. Once the file gets to our office, when we open it and we run the public trustee and we run the bankruptcy checks, we're going to say send the demand letter. The demand letter is going to set forth the balance that is owed to the association, as well as the legal costs and fees that have been added to it. And that demand letter balance is good for 30 days. The owner has 30 days to either pay that without the balance increasing. This is pursuant to the Fair Debt Collection Practices Act, or the owner can contact our office to dispute the amount. If the owner contacts our office to dispute the amount, we will then send what we call a dispute letter, which basically sets forth the basis for the balance due. If the owner then does not pay whatsoever or doesn't respond, we will proceed with the next step in the collection process, which is often a lawsuit. If the owner does respond and pays that demand letter balance, we would then close the file and send it back, and hopefully the owner wouldn't get behind again. Otherwise, we have to restart the entire process. The one thing to note about demand letters is that we can only collect for the balance that is due at that time. So if you turn over a file in mid-January and we send the demand letter out January 15th, we can collect for the balance due through January 15th. Even though the 30-day demand letter period is going to run into February, so now there might be a February monthly assessment that is due, we can't collect that off of the demand letter because we can only collect the balance that's due at that time. So oftentimes we'll get that question from managers that say, well, why didn't you collect the February assessment? Well, that's why. It's because we have to honor that 30 days pursuant to the Fair Debt Collection Practices Act. If we don't, then we and the association are liable for violations of violating the FDCPA, in which case then it's going to cost more money. So what you'll see on the status report is it'll say something like, our file is closed, balance paid in full through January 15th. Then if the owner, we of course would tell the owner, hey, don't forget your February assessment is due. But if the owner didn't pay that, the collection process would need to be restarted by the association. Let me know if you have any questions about that. The demand letter is kind of also the first opportunity for an association or our office to settle the account by waiving some of the attorney fees or by waiving the late interest. Oftentimes, if we can do it at that point, it keeps the balance, again, relatively small, and it also keeps it keeps the file moving rather than getting into lawsuit type of issues. We're also, with the demand letter, going to look at things like the individual versus the entity, the business. There's, again, different rules that apply to businesses. I will tell you from a practical standpoint, we will still send out a 30-day demand letter to most businesses as well, because when we get to courts down the road, if we have to go to court, the court is going to look for that just to make sure that there was a notice sent out. So we still honor that even though it may be a business that we're sending to. Some special collection problems that you might run into are if a debtor is self-employed, if an owner is self-employed. That's not necessarily an issue up front. That could be an issue if we get to the lawsuit stage. If we get judgment, the reason being is it's nearly impossible to garnish someone who's self-employed because they're in charge of it. Oftentimes the books will show that they don't pay themselves anything. Military, there's a lot of hoops to jump through. If someone's in the military, we have to do an active military search prior to lawsuits. We have to, if they are on active duty, we have to certify to the court that we have basically attempted to keep their rights intact. The court can require the association to appoint counsel for someone who's active military. The cost tends to be prohibitive in many actions if it's required by the court to put up a bond or to hire counsel. So you will many times on our status reports see that we are holding off if someone is active military and just holding off on the lawsuit, not the collection, just so that the association has, again, a cost-benefit analysis, keeping the cost lower for the association. Limited liability companies, the same thing. Banks, oftentimes those can be difficult to collect from the bank if the bank is foreclosed on the property and now the bank is the owner and not paying assessments. We'll see that frequently, and then we're writing letters and sending demand letters to a large corporation like Wells Fargo, who oftentimes we won't see respond. So then we're going to have to look at kind of special circumstances as far as going after them. And then judgment proof are those going to be those owners who we've sued and there's no assets to garnish because their assets are exempt, like Social Security. If they have Social Security income, that's something that cannot be garnished in general. So that's going to cause more issues. So those are all collection issues and problems that we're going to look at as we're proceeding from the demand letter to the lawsuit stage. What I've done here is I've kind of just given an overview of the process once the file gets to our office and where it goes. This matches up with what you will see on the status report. So when you're reporting back to your associations, you'll see the demand letter went out. Again, there's that 30-day period. You'll then occasionally see a follow-up demand letter sent out, or a balance due letter will be noted on the status report. What that means is that either the balance is low enough that we're holding off on the lawsuit and trying to give the owners a second chance to pay voluntarily, or balance due letter means that we've received a partial payment, so we're trying to send in another payment before we proceed with the lawsuit. Assuming we don't get payments or there's no response to any of the letters, we're going to go on to the summons and complaint stage, and that means we're going to file the lawsuit. Once the lawsuit is drafted, depending on the county it's drafted in, county court does not require us in general to file the lawsuit prior to service, so we will draft the lawsuit and send it to service. What it means by sending it out to service is we have to hire a process server, or sometimes the sheriff, to go out and officially serve the owners with the paperwork. We then file that return of service with the court, because in order to proceed with the lawsuit, the court has to, we have to prove that we did serve and notify the owner. The owner then can file what's called an answer, and what that is a response to the lawsuit. The answer, if it sets forth defenses or issues with the lawsuit, a lot of times you'll see owners say, I shouldn't owe this amount, I made payments, I never received the notices. That's a big one. If the owner files an answer, the court is going to set that on the trial track. And what that means is the court is going to set it for a pretrial conference, a trial, and oftentimes the court is going to order mediation in there. If we resolve it at the pretrial or at mediation, then we can proceed with however it was resolved. So if it was resolved via stipulation, we can proceed with the stipulation for payments. If it wasn't resolved, we're going to go to trial. If the association wins at trial, we obtain judgment, in which case we can then begin collecting. If the association does not win at trial, then depending on why we didn't win or what parts we didn't win, we would review the file and go from there. Going back to this answer stage over here, if after service the owner does not file an answer by the return date, the return date is noted on the status report that just says the owner's required to appear in court on a certain date and time or file an answer. If no answer is filed by that date, then we can request default judgment on behalf of the association. That just means that we're going to tell the court we should obtain judgment by default because there has been no opposition to it. When the court enters that judgment, we can then collect. And what we're going to be looking at when we're collecting is, again, those assets that we originally asked you for, bank levies, garnishments. Certainly we're going to reach out. We send the owner a letter that says, we've obtained judgment. Do you want to get on this payment plan to pay it off, which would stop late fees and interest from accruing, so on and so forth. If we have assets or we're able to if we're able to find assets or we're able to get the owner into a payment plan right away, then we hold off on garnishments and levies. And we also hold off on this other step, which is called questions for the debtor regarding assets. Those are called interrogatories. That's what you will see on the status report as well as the interrogatories. What that means is that the court will order the owner to fill out it's basically a questionnaire that says where they work, where they bank, what their income is, what their spouse's income is, and then they sign off on it. Once we get that, we can, again, proceed with garnishments or levies. If we don't get that, we can ask the court to set a hearing, and the owner is required to appear and tell the court why they did not want to fill out the form. Generally, the court still requires them to fill out the form, approximately 99% of the time. If for some reason the debtor chooses not to show up at that contempt hearing, we can then request that the court issue a warrant to arrest the defendant and bring them in to answer the questions. Now, this doesn't mean that there's cops randomly running all over arresting people for failing to fill out interrogatories. What it does mean is that oftentimes someone will be pulled over for something completely unrelated, like running a stop sign or having a tail light out, or they will go to do a background check. We had someone who showed up to do a background check at a facility to obtain a different type of licensure, and what happens is the background check then pops up with the warrant, or the cops run the driver's license, it pops up with the warrant. The person then gets arrested, has to post a bond, and still is mandated to fill out the questions. So in general, if you get this question from owners that says, do I have to fill this out? Please refer them back to our office, because if we have the court order, then they certainly do have to fill it out. So going back to that writ of garnishment, a writ of continuing garnishment is basically we're garnishing their paychecks. The court will allow us to garnish up to 25% of their net disposable income. When we send this out for service, we send it to the employer. So if anyone in your association has the name or information of this person's employer, that certainly helps. We send it out to the employer. The employer has 40 days to respond. And then depending on the debtor's pay period, the employer has to start sending money in directly to us, and we then turn it around to you. Every once in a while, you'll see that we have garnished the person, but the garnishment is being held. And that's oftentimes because there is a garnishment in place ahead of us. For example, if there is a child support garnishment, that is going to take precedence over the association, in which case then we're going to wait in line until that garnishment is up, because again, we can only garnish up to 25% of the net income. The garnishment and employment garnishment is valid for 6 months. We would then have to renew it at the end of that 6 months. Again, if there's a bankruptcy that's filed during this time, it's going to halt whatever garnishment may be out there. So keep that in mind. The other type of garnishment we can do is called a bank levy. We, in that case, first we get the court to issue the order allowing the bank levy. We then send it to the bank, and then we have to serve the owner. It can be difficult if the owner is avoiding service in this case as well, but we would then oftentimes send the sheriff or a different process server to try to catch them. What we will need for that is the correct name and address of the bank. We don't necessarily need the account number. We can get that off the interrogatories if the defendant has filled them out, but if it's a case like I was mentioning earlier where the defendant did not show up to court and hasn't filled them out and there's a warrant out there, then we're going to again contact the association or the management company to say, hey, do you guys have any type of information past due pay or past payments that were made, anything like that, and then we'll send it out. Once the bank's served and then the defendant is served, the defendant has 10 days to claim an exemption. So if the defendant comes in and says, hey, all of the money in this account is from Social Security earnings, the court will then set that for a hearing, an exemption hearing. We will go to court and the defendant will have to prove that the money in the account should not be available to the association because it's exempt. The defendant has the burden of showing that to the court. If the one thing I'll note, we get a lot of these calls, if the defendant's name happens to be on other accounts, like their adult child's account, they have a joint account with their daughter. When we send the bank levy over to the bank, we don't pick and choose the accounts that it goes to. All we do is have the court order that this financial institution has to hold any money from an account with the defendant's name on it. So if the bank gets that and the defendant's name happens to be on multiple accounts, it is going to hold all of the money. It can hold all of those accounts, money from all of those accounts up to the total balance due on the garnishment. We will get some angry phone calls from that because we will get people who call and say, but half of this money is my daughter's, or this money is a savings account that I was saving for something else. The thing is, we, like I said, don't get to pick and choose the account. So it's up to the defendant then to either prove that the bank should not have held the money from that account, that their name wasn't really on it, or to somehow prove that that money in the account is not theirs. And that's a pretty high burden of proof for the defendant, because oftentimes the money is commingled. And so there's no way to track, well, the money that's in the account at this point, this $1,000, 5 of it was from the defendant, and this amount was from my brother, and so on and so forth. So, but be prepared, you will get some angry phone calls from that. Angry phone calls. The new garnishment law that's in effect, many of you have heard about and have contacted us, and that's Senate Bill 2211. And it was signed by Governor Polis at the end of June. So it's going to impact things like garnishments. What it impacts in general is extraordinary collection actions. And the extraordinary collection action is defined as an action that is in the nature of a garnishment, attachment, levy, or execution to collect or enforce a judgment on a debt, as defined under the Colorado Fair Debt Collection Practices Act. So it applies to those extraordinary actions that are post-judgment. It does not prohibit you from turning a file over to our office. It does not prohibit us from sending a demand letter, the association collecting. It doesn't prohibit payment plans. It doesn't prohibit lawsuits. Here's what it does. It doesn't even prevent bank garnishments. What it does is it says that instead of the normal bankrupt or garnishment exemptions, the law now says that until February of 2021, the first $4,000 in the bank account is exempt from garnishment. So if an owner has $10,000 in the bank account, we can take the other 6. But if they only have $2,000 in the bank account, we can't take any of it. The other thing is that it impacts the process. So what we have to do now pursuant to the law is we, the attorneys on behalf of the association, have to send a letter to the owner that states that we are going to garnish them or that we're going to levy their bank account. And we have to send it, there's a timeline. We have to send it not more than, or not less than 10 days before we do it. And we have, I think we can send it something like 40 days beforehand. The owner then can contact our office in writing or via telephone to tell us that they have been impacted by COVID. And if they do, we cannot proceed with the extraordinary action. So we cannot garnish an employer, an employee's wages, if we send out that notice and the person does respond in a timely fashion and say, hey, I've been impacted by COVID, I don't want to be garnished. Now, nobody wants to be garnished, but you get what I'm saying. The debtor, though, the owner, does not have to submit any type of information or proof that they've been affected. All they have to do is call and just say, I've been impacted by COVID. They're not required to provide any type of financial hardship documentation, anything like that. There's a couple other places we have to send out the notice. So not only do we have to send it out before we garnish, but if, for example, it's a bank garn, we would have to send it before we garnish the account. And then when we serve that bank garn on the owner, we would have to send it again. And a lot of the courts are requiring us to file that notice so that they know we sent it. Again, in general, it doesn't impact most of what we're doing for collection. It certainly doesn't impact pre-judgment collection. Thus far, while we've had a few owners respond, the majority of owners haven't even responded to the letter. So ultimately, it hasn't impacted a lot of the post-judgment actions either. But again, keep in mind that it's just those extraordinary collection actions, which is defined as the levies, the garnishments, attachment, or execution. Any questions about that, please let me know. That law, so while the exemption portion of the law, the $4,000 from the bank account, is in place until February of 2021, the bill in general, as far as the notice, the letter to homeowner regarding the other types of collection actions that are considered extraordinary, is only in place until November of this year. However, according to the bill, it can be extended through February, again, along with that $4,000 exemption, at the governor's decision, at the governor's decision. So we will wait to see what happens with that. But at this point, as far as we know, it's only going to be through November. Here's some other things that are going to impact collection or that we get questions about. What happens if we're pursuing an owner and we're doing our public trustee and bankruptcy checks and the first mortgage has started a foreclosure? What you'll see on the status report is that it'll say public records or the public trustee records indicate that a foreclosure has been initiated. The date of sale is September 30th. The foreclosure, if it's by a first mortgage, can extinguish the association's lien. So many of you should be familiar with the term super lien, which is the 6 months worth of assessments leading up to the filing of the foreclosure, the NED date. But everything else that's due above and beyond that 6 months is what the first mortgage is basically going to wipe out, as well as the lien in general. The association can cure the default and proceed with its own foreclosure, or they can redeem. What that means is that you're going to get an email from one of us here in the debt recovery department as the foreclosure sale date approaches. And it's going to say, hi, does the association want to redeem? What that means is, does the association want to attempt to purchase the property at the sale, at the foreclosure sale? So in general, our office is going to file a notice that we want any surplus from the sale to pay off the association. But if the association actually, that's assuming the property sells for more than what the foreclosure amount is. But if the association wants to purchase the property, they would let us know through that email. And we would then file what's called a notice to redeem. That has to be filed. There's certain days and timelines that this is going to affect. But in general, we file it after the sale. The trustee is then going to send us the amount that would be needed to buy it, to redeem it. The association would have to put that up, as well as the filing fee, which is about $500. The other lien holders then that are behind the association, because as you remember, the association is the senior most junior lien holder. The other lien holders can then come in and pay above what the association redeemed for. If that were to happen and the association does not end up with the property, the association would be out the filing fee, but not the remaining monies that it put up. On the other hand, if no one else redeems, the association then basically becomes the owner of the property. And so then the question is, well, what do I do now? Some associations will say, well, great, we wanted that property, we're going to rent it out. Other associations will say, great, we own the property, we're going to sell it. And then there's a third association type that'll say, well, we're going to refinance it and then decide what to do with it after that. Why does any of that matter? Because when you're redeeming, you're taking it subject to other liens that may be on the property. So if you're going to take it and you turn around and sell it, there may be other liens that you have to pay off as well, depending on what was wiped out by the foreclosure, like a tax lien. Same with refinance, renting, etc. One option, I got my papers out of order here. One option that the association may have as well is going to be a receivership. Now, this is a new topic jump, so this doesn't necessarily have to do with foreclosure, although they do relate. So if there's, regardless of whether there's a public trustee foreclosure, an association can do a receivership. You will see us recommend receiverships that will be noted on the status report. So what is a receivership? A receivership is when the court is going to order that a receiver, so a rental agent, if you will, they're not just a rental agent, but an agent be appointed for the property within the association. The receiver can go in and the receiver can start taking rent from any renters that currently are in the property. The receiver can install renters in the property if the property is vacant. The receivers can also clean up the property. We're not going to recommend a receivership unless the property is either vacant or is occupied by someone that is not the owner of the property and not a dependent of the property, of the owner, I'm sorry. So if the owner is living in California and their property's been vacant, we're going to, and we haven't been able to serve them, for example, we're going to recommend a receivership, because then we can get someone in there who's going to begin collecting rent. Certainly, if there's already tenants in the property, again, we can start collecting rent from them if the receiver is appointed. That tends to create a really quick turnaround for owners when their rent checks start missing. It's a great tool to use. It's also a good tool to use if the property is in some type of disrepair. So let's say there's weeds all over, or the garage door is broken, or the home needs painted. Those are all good reasons to have a receivership, again, assuming the property is vacant or tenant occupied. Things that would not be a good idea for a receivership is if the property is in terrible condition and it's going to cost more to get the property up and running to install tenants than the balance owed. If the receiver goes in and it turns out there's mold throughout the basement and it's going to cost $30,000 to remediate the mold, then that would not be a good option to consider going forward with the receivership. And then other factors to consider with a receivership as a collection option is whether the property is already in foreclosure by the first mortgage. Some of our management companies and associations will look at a property that is already being foreclosed on, and they'll gauge the time. So if the foreclosure of the mortgage foreclosure was filed this month, that's going to tell us that we're probably going to have at least 4 to 6 months minimum before we need to worry about anything. So those associations will put a receiver in, again, vacant or tenant occupied property, for that 4 to 6 months to collect the balance. If the foreclosure is, the sale date is next month, it's not going to be worth it. We wouldn't recommend it. We wouldn't want you to do it. We wouldn't want you to recommend it to your associations. The other thing that we're going to look at is average rent for the development. If your association rents properties out for, I don't know, $500 a month, which would seem a bit absurd in this current economy here, but $500 a month and the balance is $6,000, it's going to take a number of months to catch up there. On the other hand, if your average rent for your development is $2,700 a month, well, $6,000 balance isn't going to take long at all. So that's another factor that not only we should consider in recommending a receivership to you, and that you should consider when you're discussing it with boards, associations, etc. All right, so if you're still with me, I'm going to do a quick overview of bankruptcy, and then we'll open it up for questions. So bankruptcy, there's two main types you're going to see with individuals. Those are going to be Chapter 7s and Chapter 13s. I'm sorry, we've had some 11s come through recently. Chapter 7s and Chapter 13s. 7 is going to be the quick, easy, it's over soon bankruptcy. The Chapter 7 is also known as liquidation. There's generally not going to be a repayment of secured debt like mortgage arrears or association arrearage or anything like that. And the date of the discharge for a Chapter 7 bankruptcy is going to wipe out the debt that is owed to the association by the individual, not on the property. Here's what that means. If I file bankruptcy and I receive a discharge, you cannot sue me personally and garnish me for the amount that I still owe to the association in assessments, because I filed bankruptcy and received a discharge. What you can do is foreclose, though, because you still have the lien. It doesn't wipe out the lien. And you can foreclose for the full amount that is owed, including the amount that was discharged in the 7. Again, can't sue the individual, can't garnish the individual. You can foreclose on the lien, though. So keep that in mind. With both bankruptcies, you're going to have that automatic stay. That's the part that's going to say, hey, creditor association, you can no longer collect on this debt while the bankruptcy is happening. Again, personal obligation is forgiven once the bankruptcy is discharged, but the lien remains. That automatic stay, if a garnishment is in place, a bank levy, anything like that, is going to stop it automatically. We also can't send collection letters for pre-petition, so for the balance due before the bankruptcy. We can't make phone calls. We can't do anything like that because that is considered furthering the collection action, which would be a violation of the automatic stay. In order to do any of those things while someone is in bankruptcy, we would have to file a motion for relief from the automatic stay, which ultimately in a Chapter 7 bankruptcy oftentimes isn't worth it. And this is why. In order to get relief from the stay, we have to file a motion, send it to the debtor and their attorney. They then have 21 days or so to object to it. The court was going to set a hearing, which is going to be approximately 30 days out. And by the time this is all done, the bankruptcy may very well be over because it is that Chapter 7. If a Chapter 7 bankruptcy ends up converting to what is called an asset Chapter 7 bankruptcy, that's going to mean that it's very similar to a Chapter 13, which I'm going to talk about next. In that case, the same rules apply as far as the automatic stay and collection efforts, but it's also now going to have that component where we would have to file a claim for the association to get paid on pre-petition. The claim is going to be similar to what happens in a Chapter 13 bankruptcy. In a Chapter 7, the owner can also opt to just surrender the property, or in a Chapter 13. And what that means is that the owner can say, I'm not paying on it anymore, I'm done. They can sell it, the mortgage can foreclose, the association foreclose, I don't care. Again, we can't do that while the bankruptcy is pending without relief from the stay. But keep in mind that surrendering does not absolve the owner from post-petition assessment requirement. And that's under 523A16. So even if a debtor files a bankruptcy and says they're surrendering the property, they still under that section have to continue to pay post-petition assessments until the property changes hands. Even if the debtor moves out, they're still responsible for those. Even if they've said surrender and receive a discharge, they're still responsible for those. So post-petition assessments, that's under that 523A16. We'll usually have a lot of back and forth about that with debtors that have filed bankruptcy, along with the debtors saying, well, you can't collect on the lien because I filed bankruptcy. Both of those would be untrue, but we tend to go back and forth to explain it or refer them back to their bankruptcy attorney. So in that Chapter 13, that's called a reorganization. So the Chapter 13 is that bigger, heavier bankruptcy. It's 3 to 5 years. It's an individual bankruptcy. And the debtor in that bankruptcy, while they can surrender the property, in which case we would still want to file that claim on behalf of the association, it's going to be paid as an unsecured debt because they're surrendering. But most Chapter 13 bankruptcies, the debtors have filed that bankruptcy because they're trying to keep the house or the car or pay off the tax debt. It's a reorganization. It's a repayment plan. It's at 0% interest 9 times out of 10. So what we will do when we get one of these files is we're going to want to file a claim on behalf of the association. In a Chapter 13, the association secured creditors must file a claim in order to be paid. Period. And there's a claims bar date, which means there's a deadline to file the claim. If it's turned over to our office, again, the automatic stay applies, so we can't collect for pre-petition. You guys can't either. But we're also going to monitor the bankruptcy. We're going to talk to the association about whether they want to do that relief from stay. We're also going to talk to the association about whether they want to file a motion to dismiss if the debtor stops paying post-petition assessments. So this is going to be different than a Chapter 7. A Chapter 7, 3 to 4 months, and it's generally over unless there's issues, and then it's 4 to 9 months. No proof of claim required unless it's an asset case. In a Chapter 13, not only are we required to file a proof of claim, but there's going to be a Chapter 13 plan, and the association can only object to the plan within so many days of it being filed and before the plan is confirmed. As long as the association is in the plan and the post-petition assessments, it states in the plan that those are required to be paid, the association can then at a later date move to dismiss the bankruptcy because the debtor isn't paying post-petition assessments. If the plan is confirmed and the association isn't in it, the association is not getting anything, and they can't motion to move the court to dismiss it for post-petition assessments because they're not party to the case. That is even if a claim's filed. So keep in mind that's a two-pronged thing. We have to get the case in time to file a proof of claim before the deadline, and also object to the plan prior to any type of confirmation. In most situations in the Chapter 13, the debtor is going to be paid, the association is going to be paid that past due amount over 3 to 5 years, depending on whether the property is surrendered or retained. And of course, that lien on the property there remains as well. We covered this if the owner retains the property, so I'll just skip through that slide. We've covered if the owner surrenders the property as well. That brings us up to about 12:51, so I just wanted a few minutes for questions. So one of the questions is, during a bankruptcy, can the HOA still contact the owner to advise of the HOA's intent to lien the property, or is this a violation of the stay? And the answer is it's going to depend, but in general, you want to be really careful about doing that. If the owner is in bankruptcy and it's a pre-petition debt, so part of the debt or all of the debt was owed by the debtor prior to filing the bankruptcy, it's going to be a violation of the stay if you contact the owner or if you send a letter. If it's a post-petition debt, so the balance due on the account is all from the date of filing until today, then you can send the notices to the debtor that say they're behind. I would encourage you to use the bankruptcy language that says, if this debt is in a debtor's in bankruptcy, this is not an attempt to collect the debt, et cetera, et cetera. What you can't do and what you need to be careful about is filing that lien on the property if the debtor's in bankruptcy. That applies even if it's post-petition, because when a debtor files bankruptcy, all of the debtor's property, including real property, the association, property within the association, becomes part of the debtor's bankruptcy estate, and that is basically property of the trustee to administer. So if the association does proceed with filing a lien against property that's in the bankruptcy estate and that the trustee is not abandoned, that's going to be a violation of the stay. So I would not do a blanket rule on this. I would check with your attorneys on each case if that's something you're going to think about doing, or turn it over to the attorney's office, and that way the attorney can review it and say, okay, this one's good, the property's been abandoned, this one you need to wait on, et cetera, et cetera. So I'm sorry, that was a total lawyer answer. It was a total, it depends, but it really does. In general though, the answer is I wouldn't do it. I'd be incredibly careful of it. Do I have any other questions? Okay. I'm not seeing any other questions. I'll stay on the line here for a little bit. You're welcome. Certainly, if you guys have questions, give me a shout out. You can also send me an email, aashley@altitude.com. Thank you very much for attending today. Have a good day.